Please be seated. Good morning, everyone. Thank you for being here today. We have one case set for oral submission today. I'm going to call that case first. It is Madison McDonald versus State of Texas, PD-0147-25. We will hear first from counsel for the appellant. As both counsel approach the microphone, if you could do us the favor of announcing who you are and reminding us what side you represent, that helps us keep track. Counsel, I understand that you have elected not to reserve time for rebuttal.
Yes, sir.
If you end up coming up a few minutes short, that will be fine. I'll let you have that time later if you choose to use it at that time, if that works for you.
Yes, sir.
Okay.
And I'm Michael Mowla for Appellant Madison McDonald.
Go ahead. Glad to have you here, counsel.
Thank you. I may please the court, counsel for the state. Again, my name is Michael Mowla. I represent Madison McDonald on appeal to this case. This is an appeal from the 5th Court of Appeals on cause number 0523004119CR. My client, Ms. McDonald, was convicted of capital murder under Texas Penal Code 1903A8 for the intentional and knowing death of her daughter, A.H. Now, during that transaction, as the court knows, she killed both her daughters. A.H. was 6. I'm going to refer to them as their initials, like in the briefing. And L.M. was about 18 to 20 months old. I'm asking the court, based on the one ground before this court, to reverse the opinion of the Court of Appeals, reverse the judgment and sentence, and remand the case to the trial court for a new trial. That's the relief I'm asking.
If I can jump in here, let me see if I want to ask a couple initial questions. Justice Lee on the 5th Court dissented from the denial rehearing in bank, and he had a pretty detailed opinion. In it, he does a chronology of the events leading up to the controversy at the time of the testimony of the expert. Is there anything that he put in there that you would think is wrong or incorrect in terms of the chronology?
I don't, Your Honor. I had filed a timeline of critical events Monday night, and I apologize for the late filing. I just thought it might help the court in its decisional process. And mine's a little more detailed, just as additional facts to Justice Lee, but I'm actually asking the court to adopt the published dissenting opinion on reconsideration on bond.
Okay.
So,
yes. Well, that's why I want to sort of get focused on where it is you may disagree with each other about what the facts are and anchor on what your legal argument here is. It seemed to me the first time the state communicated with, there's two C doctors here, there's Crawley and Compton, is it?
Dr. Compton was the state's expert,
okay. So
one that was appointed.
In Justice Lee's dissent, he starts with the state reached out to Dr. Compton for purposes of obtaining a consultation on competency. Is that right?
She actually testified, Your Honor, that she was retained to discuss both competency and insanity, and she said that during the hearing.
Okay, I think I'm with you there. I just want to make sure that initial communication said that the defense counsel had been communicated in connection with, had visited with the DA's office in connection with that initial contact to Dr. Compton, and that there was no objection from the defense counsel. Is that right?
Well, before the indictment, which was returned on June 14th, 2021, Dr. Compton was approached by the state for consultation regarding insanity and competency. Now, at the time, there's nothing in the record showing that defense counsel knew about that agreement at the time. I didn't see anything in the record showing that they knew.
Well, that's why I asked, because Justice Lee's dissent indicates that defense counsel, at least according to the record he was looking at, had been contacted and informed of the fact of that engagement with Dr. Compton. Maybe that's right, maybe that's wrong. I just want to know if that's different from your recollection, that defense counsel was aware of the fact of that initial
I didn't see in the record, Your Honor, that he was aware of the fact before the indictment was returned. Now, sometime later, he became aware of the fact that she was contacted for competency, But I didn't see anything saying that he knew before June 14, 2021, that she was
Okay, well,
contacted
you're
by the
anchored
state.
on that date in terms of the engagement for purposes of Article 4, I can't remember the exact code number, but, so the problem as I understand it, and please correct me if I've got it wrong.
Sure.
Is that initial engagement was looking at more than just competence and maybe also got into insanity. And when Dr. Compton met with your client for the first time, discussed with her in the absence of counsel, facts relating to the events for which she was going to subsequently be tried.
Yes, sir. She met with Ms. McDonald, Dr. Compton met with Mrs. McDonald on August 20th, 2021. The suggestion of incompetency was filed by defense counsel on July 30th, 2021. And that's page 47 of the clerk's record.
Okay. And just so, again, I'm sorry, I think we got the dates from, we'll have your Monday filing and we've got Justice Lee's dissent. I'm just trying to get clear in my own mind where the problem begins. And you say she was not re-Mirandized by Dr. Compton at that initial communication. According to Justice Lee's dissent, defense counsel was aware of the fact that that communication was going to happen. Later, when you go to trial and are objecting to the testimony, you note that she wasn't Mirandized by Dr. Compton. Dr. Clayton, your doctor, testifies that the Fifth Amendment, as she understands it, would require a communication with the expert for purposes of competency to not get into the details of the event, right? But that's I'll jump toward a couple of questions. That's the doctor's opinion about the Fifth Amendment, right? So I'm trying to get you to tell me where you think the Fifth Amendment problem starts in this case. Is it from that initial meeting? And if so, is it based on the doctor's failure to Mirandize, the absence of defense counsel, or the fact that she asked a question that would go into the particulars of this case?
The problem began before the indictment was returned on June 14, 2021. She was hired by the state for consultation on the insanity issue, okay? Now,
Let me just interrupt you, because I have the same concern. Was she initially hired for competency purposes or for competency and insanity evaluation?
the record, Your Honor, shows both. She was first initially
By the
hired
state?
by the state for both, yes.
Okay.
Yes.
And when she was interviewed that first time or that initial process, if it overlapped into the sanity issue, was she Mirandized?
There's no evidence in the record, Your Honor, that she was Mirandized. As a matter of fact, I believe in her report, in her undated report that she had filed, and that's State's Exhibit 168, there's some information there where she says that she told Ms. McDonald that things that she says, wouldn't be used against her in a later proceeding. Okay, so that goes to the opposite of being Mirandized. So, it doesn't say that I did not Mirandize her, but that comment in the report, that's a strong inference that she didn't Mirandize her.
Yeah, but that's sort of why I was getting at this recitation, at least in the dissent below, that defense counsel knew of this communication was going to happen, that this interview with Dr. Compton was going to happen. She'd already been Mirandized by the police, right?
Right.
Okay, so now she's talking to somebody that the government has sent to her, who tells her, now, okay, this is maybe an additional and different problem, but tells her it won't be used against her. But defense counsel was informed of this, according to Justice Lee's dissent, was informed of this communication and chose not to be there.
But about competency, he thought defense counsel was informed that the meeting, the examination on August 20th, 2021 was going to be about competency and not about insanity.
And, okay, that gets to the legal question. I've got the distinction, you've got Estelle. What else do you have for the idea that there's going to be a communication between a state-appointed psychiatric professional and the accused? That conversation could not possibly, if it's limited to competence, get into any facts surrounding the underlying charge. You've got the testimony of Dr. Clayton, who is an expert on psychiatric practices, but she's not an expert on the law. right? And her testimony should not be taken for that purpose, right? We don't have experts on the law. The judge is the expert on the law. So what's your best case for the proposition that counsel informed of the fact that there's going to be a competency examination should rest easy and feel not obliged to attend on the notion that that conversation will not delve into any of the facts involved in the case?
Well, Estelle versus Smith, Your Honor, I think it's pretty clear that says the Sixth Amendment right to assist the counsel was violated because it wasn't clear that counsel had been informed about the examination. And
your counsel was, right? But you said he was informed about it, but it was about competency.
well, and even so, counsel wasn't aware that examination would require inquiry about Smith's future dangerousness. So Smith hadn't received didn't have the opportunity to discuss with counsel about the scope of the examination. And there are other cases as well, but Estelle is the main Supreme Court case that discusses it. Bottom line is, I didn't see any record evidence showing that trial counsel, defense counsel, knew that Dr. Compton was going to get into the facts of the case and the issue of insanity. And then, as you recall, Your Honor, later on, before she was appointed as a disinterested expert by the court based on the state's motion, she admitted both in her report and on the stand that she had already made up her mind about Ms. McDonald's insanity before she even did the examination. The examination for insanity took place on August 3rd, 2022. And she said this in a July 27th, 2022 email, that's Defense Exhibit 17, that she had sent to the state saying that, nothing's going to change my mind, regardless of what I hear from her. Now,
where does that anchor in your argument here? Is that a due process problem, or is that a Rule 702 or 3 problem as to admissibility?
Well, the claim was a Fifth Amendment claim with regards to, her right to counsel, and, her right to have counsel present.
Okay.
So, the Fifth Amendment, it was a Fifth Amendment claim filed by trial counsel, and the argument on appeal is a Fifth Amendment claim. Her testimony should have been suppressed because it was a motion to suppress filed by trial counsel. And, of course, based on the suppression, that would, effectively disqualify her. That's the reason for the language of disqualification language. The bottom line is, Your Honor, she was not a disinterested expert. Now, the issue 1 on the direct appeal was the sufficiency issue. That, of course, the jury had rejected it during the trial, and the Court of Appeals rejected it. I had filed that as one of the grounds for PDR. The court granted it only on this ground. But the bottom line is that when a jury is presented with an expert who's represented as a disinterested expert, and the expert is not disinterested, the question is, how much emphasis would a jury place on that expert's opinion? Because experts, and
But again, what I'm struggling with is you're sort of mixing legal concepts, at least in my mind. The expert, let's say I agree with you, expert was not disinterested.
right.
In my view, and correct me if you disagree, that's anchored in a Texas statutory provision about who can be retained as an expert. Where is that in the Fifth Amendment, and where is that in sufficiency?
Well, the 46C 103 talks about disinterested experts, okay, appointing disinterested experts for an insanity case.
And the remedy for a violation of that is what?
Well, what happened here is that an expert that was not disinterested went and interviewed Ms. McDonald without counsel present.
I'm with, okay, so,
Yeah.
yeah, but
So that's where the Fifth Amendment violation. So the argument isn't that you should reverse simply because she was disinterested. She was not disinterested.
Right.
That she was an interested expert. The argument is that her.
So it's sort of an atmospheric loss on your due process problem of the initial interview was done beyond the reasonable scope of the consent of counsel getting into insanity, and then you have the statutory problem of the expert is not disinterested. But even if the trial court has erred in the qualifications of the expert, is the evidence available for the jury to consider for purposes of against a great weight and preponderance?
Well, not erred on the qualifications of the expert. You know, there's no argument Dr. Compton is a qualified expert. Now, erred on whether she was disinterested. The fact that she was not disinterested is why Fifth Amendment violation occurred.
But if I remember the Court of Appeals panel opinion correctly, it indicates that that opinion from Dr. Compton, let's assume she was disqualified by a combination of the manner in which she had the initial conversation and the fact of her apparently being not disinterested for purposes of the statutory prohibition. The panel said there's more than enough evidence without that testimony. So if we take your sufficiency challenge, take out the expert opinion, there was more than enough evidence before the jury to reject her insanity argument. Now, you and I know that there's obvious mental, well, there would appear to be mental health issues involved, hence the initial engagement of the doctor. But the standard for insanity to avoid legal culpability is high. Yes?
Yes, Your Honor, it is,
So,
but
how do you answer the Court of Appeals panel decision that the jury didn't need Dr. Compton's testimony and the result would have been the same?
yes, sir. On pages 20 to 23 in my brief, I've set out 23 well-cited in the record factual assertions showing why she was insane at the time. And we take a step back. It's my argument that no sane mother protects her children against serious harm that she believes to be real by killing them. So, you know, when she went, presented herself, do you recall?
I know, but you and I are now having the conversation on the back of a bus that regular people would understand. This is nutty. Mothers don't kill their children.
Right.
But going back to England in the 1700s, we've developed a standard for when people are legally responsible for their conduct. And it is not, this is nutty. It is, I understood basically that this was wrong. Right? And you had to, for purposes of sufficiency, you had to show no reasonable juror, or the great weight and preponderance of the evidence for this purposes was against any conclusion a jury could have gotten to that she would have understood that what she was doing was wrong.
Well, she, during her interrogation, or it was an interview with Detective Mayorgas of the Irving Police Department, she effectively said, you know, I'm paraphrasing because it was a long interview, that she did what she did to protect her children from, you know, this, you know, child trafficking, child sex conspiracy that she thought existed. And, you know, anyone who disagreed with her, police, whoever, her parent, her mother, the father of the girls, was also part of the conspiracy. You know, so in her mind, she committed this horrible act thinking that she's protecting her daughters. So, you know that's not just nutty, Your Honor. That's insanity.
Counsel, let me ask you a question.
Yes, sir.
Why doesn't the bringing of her own mental health testimony, for instance, the idea of a Legrand waiver, why does that not resolve any Fifth Amendment problems in this case?
Well, because again, the initial issue was simply competency. It was, you know, a suggestion.
But your argument here to this court is that this is effectively a Fifth Amendment violation.
It's a Fifth Amendment violation.
Okay, so if the witness here constructively testifies through bringing their psychological expert to testify as to mental health and insanity, how is that not a waiver of their Fifth Amendment right under Legrand?
Because Dr. Compton was presented as a disinterested expert to the jury.
Well,
That carries
Dr.
great
Compton
weight.
was presented as a state-retained expert on the competency, but the actual testimony at trial was, okay, sometime after that, you were appointed by the court to conduct an insanity evaluation. So that part is neutral, but before that it was, you have been retained by the state, correct?
But
So-
right, but again, initially she was retained by the state for both insanity and competency. She's a state expert. I've never seen a situation where a person went from being an expert for the party to a disinterested expert appointed by the court.
Let me try it a different way.
Okay.
If this expert, Compton, had been called by the state
Yes.
as a state's witness,
Yes.
not as an independently appointed court, you would concede that by calling their own witness to testify as to insanity, they then allow the state to bring in testimony and do their own evaluation of the defendant and testify as to the results of that evaluation. They effectively waive that Fifth Amendment privilege under Legrand, at least to a limited extent, correct?
Only if it was represented initially that she is a state
All right,
expert.
then let me ask you this. If that's your position, then isn't the harm analysis, if we ever get there, isn't it that there was one retained witness on one side, one retained witness on the other side, and the jury simply didn't get a third neutral? It isn't so much that Compton testified, it's that there wasn't a third court-appointed neutral, because the state would have been able to call Compton as their witness once the defendant brought their own witness on insanity, right?
But that's not what the state did, though, Your Honor. The state presented Dr. Compton as a disinterested expert, okay? She went in for a competency examination, and it's true that Dr. Clayton's opinion is not a legal opinion, but I've never seen a competency report have all the details of the offense. She went in as a state expert to examine Ms. McDonald for competency only, and she got into things other than competency, mainly the issues of the offense, the facts of the offense. And then
Still having problems with this Fifth Amendment issue. The defendant put insanity squarely at issue by pleading an insanity defense. Under our previous case law, principally Legrand, but extended through, Paulron and Chamberlain, that means there's at least some limited waiver of the Fifth Amendment rights. It is constructively testified. So if you're focusing this on Fifth Amendment, you've got to explain for me how I get past that.
There's a waiver only if it's presented to defense counsel, because she was retained by counsel, or she had an appointed attorney at trial. If it's presented to him that Dr. Compton's going to be going in, or whoever is going to be going in to examine her, is for the purposes, as a state witness, the state expert, excuse me.
Well, your point is that the horse is already out of the barn door by the time he's had the initial investigation.
The horse is already down the street, Your Honor, running down the street, yes.
Okay, counsel, so your light is on. I think you have 1 minute left if you want to use it later.
Okay.
All right, thank you.
All right, thank you.
We'll now hear from the counsel for the state.
Morning. May it please the court. My name is Jaclyn O'Connor Lambert, and I represent the state of Texas, Dallas County, in this appeal from Madison McDonald's conviction for capital murder. Now, in this proceeding, we have it's been framed as one issue, but the reality is there are two very distinct issues before this court. The overarching issue is, did the trial court err by admitting Dr. Compton's testimony in this case? But really, there's two distinct arguments. One argument is that she shouldn't have been appointed under 46C. And that's not an evidentiary objection. That's just an objection to the trial court's appointment order appointing Dr. Compton. The other is the Fifth Amendment claim, and that is an evidentiary objection. I'd like to start by talking about a few of the questions that were explored by Appellant's counsel on direct appeal. I believe one of the questions was about the dissent and about the chronology that was outlined in that. I would say that it was mostly accurate. There's a few things that I would point out that were incorrect. One of them is that the dissent takes issue with when the defense actually was on notice that we were going to call Dr. Compton as an expert. And I believe that the record is clear that was developed at the hearing that the minute that Dr. Compton issued her insanity report, that was forwarded to the defense, and the parties knew at that point that we were going to trial and that the issue was going to be insanity. And that was 8 months prior to trial. That was always going to be the issue in this case. So when we sent that report from Dr. Compton to the defense, at that point, everyone said, all right, let's set a trial date. We're going to trial, and the issue is going to be insanity. So this idea that they were surprised or they didn't know up until the point of trial is just not true. Additionally, the dissent talks about how she was not properly admonished before the competency exam, and that is also untrue. In Dr. Compton's competency report, she talks about that she gave the relevant admonitions that are required under the statute. And there's two statutes that are really important as it relates to competency. The first statute is 46B.024, and that is the statute that outlines the factors that a doctor is to consider when they do a competency evaluation. And in that statute, one of the factors is the pertinent facts of the offense and the defendant's state of mind at the time of the offense. So this concept that she was not allowed to talk to Madison McDonald about the offense or about her state of mind is just not
Okay,
true.
but that helps you, but maybe it hurts you too. Because I think Justice Lee starts that dissent, that's why I want to start with that chronology with, defense counsel was informed of the fact, and I think counsel opposite has agreed with that this communication was going to happen between Dr. Compton and his client.
Yes, and they agreed
But-
to that.
But, and as you pointed out, the statute says, with respect to competency, she may get into that subject matter. Where was defense counsel informed, and when was they informed that she would also be an expert on insanity?
Specific,
Obviously not then, because the issue hadn't been raised.
the issue had not been raised by the
by the-
defense
By the
yet.
defense counsel.
Correct.
But if the state intends to use her for that purpose, aren't you running the risk, if you are going to get into the subject matter of the events, not informing counsel opposite that this witness may potentially be a subject matter expert on mens rea, guilt or innocence at trial?
Well, I
So the
think,
defense counsel has an informed basis to decide whether he wants to attend, to document the fact that these admonishments were given at the beginning of the inquiry. Because right now, we're going off Dr. Compton's notes, right?
it's actually in her report on the first page that she gives
so
the
it can't be
admonition.
un-
Oh, wait a minute, counsel, and I may be missing it, but it says on that report, if I'm reading it right, any statements made during the course of a competency examination could not be used against her.
That's correct.
Okay, so what you're talking about is that she was given a Miranda warning?
So the
Where do I
statute,
find that?
46B.007 is actually the statutory provision that protects a defendant's Fifth Amendment rights as it relates to competency.
Well, there's a 46B00 at the back of this, but it's pretty, I mean, just to be clear, you're expecting a layperson to understand fully the implications of this. Admissibility of statements and certain other evidence, a statement made by a defendant during an examination or trial on Mrs. McDonald's incompetency, the testimony of an expert based on that statement, and evidence obtained as a result of that statement may not be admitted in evidence against Ms. Donald in any criminal proceeding other than at a trial on Ms. McDonald's incompetence or any proceeding in which Ms. McDonald first introduces into evidence a statement, testimony, or evidence described by this article. You think a layperson who has serious mental illness should be able to extrapolate from that to an effective Miranda warning?
I'm assuming that her attorneys discussed that with you because it is, we discussed that with her because it is the statutory provision that governs and protects her Fifth Amendment rights.
Was
And
she
then,
given this report? I mean, obviously not at the time of the evaluation.
was Madison McDonald given the report?
Right, this report was created as a result of that evaluation.
Correct.
So it couldn't have been in existence when she did the evaluation.
No, but the defense knew that Dr. Compton was going in to do the competency eval. So I'm assuming that they discussed all the
But what I
relevant.
heard you said was that this report had evidence in it that Dr. Compton effectively gave her those warnings, and I want to see it.
Oh, on the first page of the report, she lists the informed consent on the very first page. And she says that she informed her that a finding of incompetency neither hurt nor helped her case, and that any statements made during the course of the competency could not be used against her. And then she cites the article, and so in her testimony, she said she explained the admonitions to her, and that what Article 46B.
I get that helps you with the statutory issue, but you're treating the statute as a sunset on the Fifth Amendment. It doesn't work that way. It's the other way around, right? I mean, this statute could have protected her for purposes of competency, but having chosen that lane for this testimony and potentially misled the accused, who's already, you've got to be more, this is a sensitive setting, right? You've got someone with known mental health issues that your person is talking to without counsel present on the basis of a statutory representation, which is repeated live, that nothing that is said here is going to be used against you at trial. Why haven't you poured concrete around the feet of your expert into the lane of competency, but not insanity at trial? Because you've told her, nothing you say here is going to be used against you at trial.
Why have we not instructed Compton that she needs to 100%?
Well, I don't care what you
Why is that not dispositive on the Fifth Amendment issue?
Problem. But if defense counsel objects to her showing up and saying, now I'm going to talk to the jury at a guilt or innocence phase about whether she's guilty based on what she told me during what was supposed to be a competency evaluation, where she was assured this was not going to be used against her at trial.
Well, she was assured that it could only be used against her under certain circumstances, and those certain circumstances happened at her trial. That statute says that it can be used against you if the evidence is first brought up by the defense, which is exactly what happened in this case.
Well, that's the point of Justice Kennedy's opinion with respect to waiver of the Fifth Amendment, which Judge Finley was asking.
Yeah, and that's what I wanted to get at. I mean, obviously there has to be harm here, so let's talk about harm. And I mean, the hypothetical in my mind is the judge says, okay, Dr. Compton, you can't testify. The defense puts up whatever it puts up, and then in rebuttal, if there's contradictory statements that she made to somebody else, they get to call Dr. Compton back, right, and say, well, didn't she actually tell you this? I mean, assuming it's a Miranda and Fifth Amendment aside, as long as it's a voluntary statement, you can use those to impeach. Am I?
Yes, correct. And there's no evidence that the statement was involuntary. Ms. McDonald participated in these proceedings throughout. She was very cooperative with both sides, and there's no issue of voluntariness with any of the evaluations that were done. And I agree with that 100%, that once the defense presented the evidence through their expert, that opened the door to all of that evidence. There was a waiver of the Fifth Amendment right then and there. The statute allows for it and the case law allows for it, because even if it was illegally obtained, it could have been used for impeachment. And then under the statute,
Well, when you said could have, just to be clear, I may have got the facts wrong, but all of Dr. Compton's testimony in this case as to insanity was rebuttal testimony, correct?
correct.
Okay, just to be clear.
And also to be clear about that, when the state presented Dr. Compton during the case in chief, or during the rebuttal, we did not elicit any information from her about any of the contents of the competency interview. That was done on cross-examination by the defense.
But you knew she had that information.
We believed that all the information she obtained at the time of competency was pursuant to the factors outlined in the statute. We did not believe that there was any information that was illegally obtained at the time of the competency interview. She's allowed to ask about all of those things. The real question is, how is she allowed to use them later? And I think that's the real question in this case, is how are they, they're going to learn things during a competency interview, and what are they supposed to do with that information? They can ask the same questions again during the insanity if we want to wall off competency.
Okay,
they
but
could then ask
hold
the
on.
exact same question.
This is sort of like they could ask the same questions, all right? But here, this is kind of like a reverse Miranda. They didn't go to her and say, anything you say can and will be used against you. They went to her and said, nothing you say can or will be used against you. And she then answered her questions. Yeah, later she could come back and say, now we're doing the insanity phase. Oh yeah, everything you say can and will be used against you. But to try to merge those when in the one you have a mentally ill woman, at least by the defense's assertions, who may not have a full understanding of this. You have a really fairly complicated extrapolation from some fairly obscure statutes, and you literally have a reverse Miranda situation. Stage one, competency, nothing you say can be used against you. Stage two, insanity, she could have used the same questions, but it would have been under the, everything you say can be used against you. And you're arguing to us that, it doesn't matter. She was sufficiently warned, and therefore, we didn't put that in. We just put her up so the defense would. That's hard to get around.
I think that, well, for one, I don't think there was any nefarious intent. I think Dr. Compton was just trying to follow the statute, because that's the guiding principle that she has when she conducts the exam. I think also that, again, there's this waiver principle that anything comes in once the defense presents the evidence. And so I'm assuming that
Isn't that why the defense can have their interested witness, the state can have their interested rebuttal witness, and the court, under this statute, which is what this expert was appointed under, may appoint a disinterested witness, specifically to avoid that problem. Isn't that the reason for that statute?
I think the reason for the appointment statute is because the trial court has to make a preliminary determination of whether the issue of insanity should go to the jury at all. And so the statute allows the trial court to appoint an expert to advise them on whether there's actually an issue of insanity.
And that expert tells the defendant that nothing they say in that competency can be used against them.
Nothing can be used against them except under certain circumstances. So, I mean, that's the caveat. I'm not trying to parse words. I just think that that's important, because they're being told it can't be used against you unless, and then there's two circumstances of when it can be used against them: in a competency trial, and then if the defense brings it up first. And the latter is what happened in this case.
I mean, I feel like that's where we're stuck, because in a normal Miranda problem, the defense can maneuver around. Like, so if a statement is illegally obtained, the defense can maneuver around that so that statement never comes in. But but in a mental health context, we're stuck because it's always, I mean, it feels like, and maybe I'm putting words in your mouth, or maybe I'm wrong, or both, but like, I mean, it feels like we're stuck no matter what because we're in a mental health context. Because anything she says to a mental health professional by definition is almost gonna come out regardless. I mean, can you comment on that?
I would agree with that. I mean, I think the case law is clear that the constructive waiver actually happens when they talk to their own expert. And so there's this sort of like concept of waiver of the Fifth
Talk to
Amendment.
or offer testimony of?
When they talk to their own expert, when they break their silence and speak to their own expert about whatever mental health issue it is, whether it's insanity, competency.
Just so I'm clear then, if I'm a defense attorney and I get a mental health expert to talk to my client for purposes of evaluating whether I can assert an insanity defense, and I don't call that expert at trial, you're telling me that that is an effective waiver of the client's Fifth Amendment right?
She's talking about testifying.
No.
That's what I'm saying,
Right.
testify.
Not
So it's
until
not when
the-
she talks to the expert, it's when
There's
the
a-
expert testifies.
The case law says, Legrone and his progeny says that the constructive waiver happens at the time of the interview, but the evidence doesn't become admissible until the defense offers it first, and then the state can put in the rebuttal. And so going back to your question, I think that, yes, in a mental health context, that is a risk that you take when you want to raise a defense of insanity, is like you're basically allowing your client to be interviewed by a court's expert or a state's expert, but in the interest of potentially having favorable evidence come out of that, right?
But you have the right to have counsel present, right, during that interview?
In my practice, I don't know that attorneys attend any of these
But
evaluations.
do they not have the right if they want?
They have the right to consult with the attorney before or after, but they don't typically go, so.
What are your thoughts on Satterwhite out of the Supreme Court in the late 80s that talks about interviewing defendants and the facts of the case?
I'm not familiar with that case, Your Honor. I apologize. If you give me a little bit of the facts,
It's pretty much what we're talking about,
Okay.
and that is that the expert went in, talked to the defendant, got admissions about how the crime was committed, the lawyer didn't know about it, and subsequently used that testimony in the case in chief and in the punishment phase. It was a death penalty case, but
Okay.
the legal issue is still the same.
Okay, I think the distinction between that case and ours, which is very similar to Estelle and ours, the distinction, is that one, the defense attorneys knew in this case about both evaluations ahead of time, so they had the ability to consult with their client prior to that. Secondly, she was given admonitions prior to both evaluations. That didn't happen in Satterwhite or Estelle. And then third is the waiver concept, that if that had occurred, if the defense didn't put on any evidence, that would not be admissible.
But I guess my only concern is if the defense attorney thinks that his client is being interviewed strictly for purposes of competency and not sanity, he's kind of at a disadvantage.
I would
Because the
agree with
competency
that.
would just strictly go to, can he be tried or not? The sanity is just, it's a defense that they're using, right?
And I think that's where we disagree about, I think Appellant and I disagree about what occurred at the competency, because I believe that Dr. Compton was following the statute, as she's supposed to do. And the defense has characterized that as she went outside of the information that she should have obtained during that. But I think the statute specifically allows it and then protects it unless it's brought up by the defense first.
I get you on the statute. Where's the due process clause on that? Because just because the Texas legislature passed a statute doesn't mean it's automatically a priori
Right.
constitutional.
I mean, I don't,
I suppose someone might argue that the text of the statute gives enough notice that if you raise an insanity defense later, that this conversation could be used. But now we're all counting on the accuracy of the written report from the expert. There's no video of this event. Defense counsel's not present because he thinks it's about competency. And I guess the point is, well, he should have known there was a risk because the statute informed him of that.
right. I mean, I think that's true. Did I answer your question? I apologize. I wanted to come back to that because I wasn't sure if I answered the question that you were asking.
I feel like my question was half question, half comment. It just feels like once we get into the mental health arena, it's almost a civil case at this point, and everybody gets access to everything. Is sort of, I feel like we're just trapped.
Right. Well, what I can say is that if they had not presented Dr. Clayton, the state would have never presented Dr. Compton. That evidence would not have come in. That we would have only, and that's why it was offered in rebuttal. They pled not guilty by reason of insanity. So technically the issue is before the jury, but we waited specifically until Dr. Clayton testified before we put on any evidence. And even then, our presentation of Dr. Compton on direct was limited to the issues of insanity. And we did not address any topics that she talked about during competency. That was done on cross-examination. And so, I mean, I think Did you have a
No, go ahead, finish. I'm
Okay.
sorry.
The other thing that I wanted to point out, and we haven't talked about this yet, is that the statute does allow the same expert to do both competency and insanity. It does specifically allow for that. And so there is this, and in some situations, the expert will go in and they'll do competency first and then do insanity all in one proceeding. And so, again, they're going to necessarily get information that would be relevant to both competency and insanity during that evaluation. And I think that's the purpose of the statute, is to protect that information so that it can't be improperly used later.
Do you think there's a limitation, pretend or assume that this is a violation, a Fifth Amendment violation to talk to her about the facts of the case during a competency evaluation? Is there a limitation? Is the limitation you can't use the statements, she told me that X, Y, Z? Or is there even a limitation of using those illegally obtained statements and forming an opinion? Do you think there's a distinction there?
I think that, well, again, I would of course take the position that nothing she obtained was illegal, but if we were to assume that, let's say there was something that was determined to be improper, I think that would be excluded, that we wouldn't be able to talk about that. It would have to be redacted from the report. But again, when we're in a waiver situation where the defense has presented the evidence first, I think it's all admissible under the law.
My question was, did her lawyer have full knowledge of the expert's opinion on her sanity before he decided on his trial strategy?
Yes.
That was in a report that he was able to review, and before he put his expert on the stand, he knew all of that.
Yes. The defense gave notice of insanity, and then a short time after that, Dr. Compton went in, and then as soon as her report was sent to the state, we forwarded it to the defense, and so they had notice of that. And that was about 8 months prior to trial. So that was the point at which we all knew we were going to trial, because there was a chance that if Dr. Compton found her insane, that this case was not going to trial. If she had told us that she believed she was insane, that would have been the end of it. And so we send Dr. Compton in.
Insane or incompetent?
Insane. Or incompetent as well. We would have sent her for restoration. And honestly, at the time that Dr. Clayton did initially evaluate her, I think she was incompetent. But she had been on medication for those 3 months in
Just
between.
help me refresh my recollection on the timeline. Who was it that first suggested that there was a need to communicate with her about competence for trial? With the state, wasn't it?
The defense.
The defendant, okay.
Dr. Clayton saw her first. They had a report from Dr. Clayton.
Oh, yeah.
Dr. Clayton. And, but the report, there's very strict timelines in the competency statute. I apologize, I think I'm out of time, but may I finish my answer?
Of course, you're not out of time.
Okay. There are very strict guidelines in the competency statute about when that report has to be filed with the court, and so that time had lapsed. And that is when the prosecutor said, hey, can we send Dr. Compton in to do another competency? And at that point, she was competent. She had basically been restored in the jail. But if she had said she was incompetent, she would have gone to the state hospital for restoration, and that would have been the process. So I think it was the same thing with insanity. There is a strategic motivation for the defense to allow Dr. Compton to go in, because if she found her insane, that would have been the end of it. But then once we got her report and once we knew what the findings were, then that was the point at which everyone knew we were going to trial on insanity, and that's what happened. And that was about 8 months prior to trial. If there are no further questions by the court, the state would just ask that you affirm the Fifth Court of Appeals opinion in this case.
Thank you very much. Counsel, was there anything you'd like to add? You have a minute if you'd like to use it.
Just very briefly.
Before you start, counsel, one quick question. Assuming error, harmful or not, and why?
Well, the error is harmful because, again, Dr. Compton was presented very incorrectly as a disinterested expert, and that does sway, in my opinion, a jury's opinion. This case, this was a very mentally ill woman who committed a horrible act thinking that she was protecting her kids. Okay, and again, that's in my opinion very insane. So you have an expert that comes in, retained by the state for both competency and sanity. Defense counsel is not told that she's going to be interviewed. His client's going to be interviewed about insanity, and that's why, he didn't have the option because he didn't have the knowledge of that. That's where the harm comes in, because this expert, and state counsel also had talked about, well, it doesn't matter how she was retained. Well, in volume 8 on pages 57 to 58, the state's attorney, the prosecutor, was arguing that we can rescind the order under 46C as a disinterested expert and just make her our expert. The state knew that they made a big mistake by proceeding to represent Dr. Compton, the disinterested expert. And that's where the harm comes in. If a jury hears from the court's expert, the disinterested expert, that, yep, you know, she understood the wrongfulness of her actions, that places a big emphasis, you know, jury places a big emphasis on that. You know, and there's just, you know, I mean, I would if I hear from who I believe to be the person appointed by the court, not the hired gun of one of the parties. So this isn't a case.
Two questions there.
Sure, sure.
They did specifically identify during that direct testimony, the rebuttal, that, okay, sometime after that you were appointed by the court. But before that, they said you had been retained by the state.
Yes.
Correct. So the jury heard that this expert was retained by the state.
Well, was that during the sub rosa hearing, the 705 hearing, or in front of the jury? Because there's a lot of testimony from Dr. Comic that was mixed.
It says it's the direct examination. The question was, okay, now can you, to clarify at that point, you had been retained by the state. Answer, correct. To do the competency evaluation, is that right? That is correct.
But during voir dire, when the defense counsel was asking, and this was page 243 to 244, when the defense counsel was going to ask the jury about, you know, experts being hired by one party or appointed by the court, the state objected, and they approached, and counsel for the state wasn't allowed to ask that question. So the jury was picked based on the understanding that Dr. Compton was a disinterested expert.
I have one, I know you're almost out of time. I have one question I think that you can do with a very brief answer.
Sure.
If I read it correct, and I could be wrong, so correct me, but the Court of Appeals did a 44-2B analysis, right? If we find that the Fifth Amendment is preserved, do we send it back for a 44-2A analysis?
Excellent question. I'm of the opinion that this court can make the decision that this is a 44A error. 9 very able judges that can do that. I don't think it needs to be sent back.
That's a legal question, isn't it?
Huh?
That's a legal question, right? We would review it de novo anyway, right?
Yeah, I think it'd be resolved right now by the court instead of, you know, just staying, you know.
Okay, counsel,
Yeah.
why don't you take about another 30 seconds or so, if there's anything you think we haven't heard that we need to hear, if you could.
No, Your Honor, I think we got to the point of the matter pretty clearly.
Any further questions? Okay, I'd like to thank both counsel very much for your arguments here today. This was the only case we'll take under submission. This case is now under submission, and we will stand in recess until such time as we don't.
All right.